you still have questions, at the last slide, you have the email ID and you can directly connect with me and I will respond to you on one-to-one basis on any other questions which you have on this particular aspect of the presentation. So the presentation is titled as Protecting Your IP in India. The presentation basically gives an overview of the IPR scenario in India and how you can basically protect your inventions in India, specifically the significance of IPR increasing day by day, and therefore it becomes important for you to have innovations which are protected, to commercialize them and to have economies of scales and profits out of these innovations. So welcome to the webinar. The agenda of the webinar would be introduction about EBTC. As you know, European Business and Technology Center is how we address EBTC. The IP office in India, its structure, how it is commanded, under which ministry it falls, and the laws, acts and regulations which govern IPR in India. Interestingly, we conducted an IPR survey at EBTC to understand the requirements of the European companies and also to understand what specific issues they have in the field of IPR. All these things would be provided in the IPR survey findings, and subsequently as we go along in this webinar, we are going to discuss some of the issues which we basically obtained from the seminar, and we are going to even share the conclusions and findings of the seminar. Now this survey was conducted in association with Indo-German Chamber of Commerce and EIRC, which is the Europe-India Research Center, and we had a large number of European companies participating in this survey of all sizes, medium, small and large. Subsequently, we will move to trends of patents, trademarks and geographical indicators in India, what these trends depict and what they show as we go further in the presentation. We have correlated a few IP challenges. We're not discussing everything because it will take a very long time. However, you are welcome to see all the challenges in a 5-year publication which is available on EBTC's website, wherein we have all the issues including clean tech sector, specific findings which are more related to the policy aspect of the IPR and even the clean tech sectors where EBTC operates. And then glimpse of development of case laws and intellectual property, which is basically about something, how the case law is developing in India, what it holds in future for the European companies, and how the law shapes up, and after it shapes up, how it is going to affect the European companies going further in this. And subsequently, we will have a question answer session wherein you would, as I said, would be able to basically ask questions specific to the presentation or anyway or thereafter related to any issues in IPR, and we would be able to address those issues. So moving on, I just wanted to say EBTC's objective is to facilitate cooperation in business and research, specifically in the area of clean technologies. As you know, clean technologies are of great significance in future. They are environmentally friendly, and subsequently EBTC has a mission to bring green and clean technologies into India. And it is in these clean and green technologies that IPR matters the most. As the innovations are developed, they require huge investments, and subsequently these investments need to be encashed, and this long-term research, which is painstaking sometimes, needs to be commercialized, and subsequently the ROI has to be returned out. So EBTC basically facilitates green and clean technologies cooperation into India, wherein Indian companies and European companies could collaborate on these aspects. It also acts as a reference point for conducting, say, in market intelligence. If some European company is interested in knowing the opportunities in a particular space, or it is interested in incubating services, or it is basically looking for a cluster-to-cluster collaboration with Europe, or even transfer of technology into India. So these are specific reference points where we operate around. the capacity to reach European businesses and research communities. EBTC has a large network. Subsequently, we are able to provide collaborations to research community, to bring research to market, and stuff like that. And it is here that IPR becomes extremely important to manage, and we provide advice on these aspects also. Furthermore, it basically allows EBTC works with Indian Chamber of Commerce, with Indian researchers, with Indian research community, with Indian clusters, with small and medium enterprises in India, and also in Europe. So it is the best platform and a powerful platform to bring European and Indian communities together into India for clean and green technologies. EBTC has 4 offices, headquartered at Delhi, followed by regional offices at Kolkata, Mumbai, and Bangalore. These offices are located at each geographical regions as to cover the entire spread of geography in India. As I told you, we operate in green and clean technologies, and therefore our main focus sectors are biotechnology, energy, environment, and transport. Of course, IPR is the one which basically cuts across each of these sectors, and therefore it's not listed as a specific sector, but we operate and provide help in IPR also. So as you can see, in biotech we operate on green biotech, which is normally related to agricultural processes, transgenic plants where under specific conditions plant could grow faster. In energy, for example, we work on renewable energy, specifically in area of windmill, solar, and others. In environment, on clean water, clean air, and other things. And in transport, specifically on rapid transit, electric cars, and other stuff. So everything related to clean and green technologies. Subsequently, we have a 4-point structure wherein we have from collaboration to incubation to basically creating collaborations for technology transfer. So it is basically a platform to promote India into Europe and Europe into India, and for making collaborations between India and Europe, and providing it also provides information intelligence for example, if specific information on specific sector is required in Europe, it is available from EBTC, and likewise if you require any specific intelligence with respect to clean technologies or renewable energy or biotech or environment, it is again available at EBTC, and EBTC has sector experts who can actually dig into and provide you with specific information. Supporting the market entry process from beginning to end. There are huge challenges when you basically enter into India with respect to for example, let me take a example of a company who wants to come into a specific sector. At the very outset, you have the standards. There may be difference in standards, or Indian standards may not comply to certain very innovative and new standards which have been applied across the world, and therefore the first barrier is provided there. Then there are challenges with respect to protecting the inventions in India, with respect to forming collaborations, identifying exact partners, the opportunities available in India. Mind you that India is a large extent, and therefore the opportunities might be available in any specific geographical region or maybe across India. So it is the intelligence to select the right geographical location, to identify what has to be protected, how it has to be protected, to basically provide a clean flow or a smooth flow for how to move around and see the standards and how to mitigate the standards so that whatever products are there which can be easily diffused into Indian markets. And then there is a whole process of market entry into India from beginning to end, where EBTC holds of the European companies and provides them access to India. We also support incubation services for businesses and R&D, and subsequently we help in a kind of a space for European companies to start their operations in India. as you can see, we basically provide demand-driven services on the outside where IPR requires capacity building. There are other sectors which require market insights, exploration, partner identification, strategies, technology incubation, and specifically platforms for mutual collaborations either between clusters or between networks. And therefore, based on the demand, we specifically design our product lines or our services, and we deliver accordingly. We basically do in EU-India collaboration. We also help in research to innovation. We also provide commercialization of technologies. In certain cases, when the EU technologies are not adaptable in India, we also go through the process of making the technologies adaptable and ensuring that the adoption in India is smooth and seamless. And then basically demonstration and impact matrix. It may be a pilot project where it could be a demonstration of how the EU technologies could be absorbed and how they can bring change into India, or how they can be beneficial to Indian organizations or India at large for building a clean environment in India. To these, I think these are the initiatives which we have taken, and we are doing extremely well on supporting the EU companies getting into India. As you can see, this is a technology transfer and deployment model. On the right side of mine, from your right side, if you see on the left side of the slide, looking straight into it, you will find that there is a demand for technologies in India. We basically ascertain what kind of demand it is, what kind of technologies are to be required. We subsequently list what technologies, clusters or networks are available in Europe, and then we do the initial preparation of such a thing so that we can basically move to the next phase where technology transfer or matchmaking or collaboration or joint ventures can happen. So in short, I can say that there is a supply side on Europe where technologies are available. On India, there is always a demand side where technologies are required, and subsequently using this model of either matchmaking or technology transfer or deployment or collaborative and collaborations and joint ventures, we prepare both sides to enter into a joint collaboration for clean and green future in India. Before I move on to the other part of the presentation, this is an IPR Helpdesk, which is basically provides help to European companies, specifically SMEs coming into India. As you can see, the presentation is basically, there are 6 categories of services which we provide. The first one, which are green, are approximately more towards information dissemination, and these provide information about IPR rules, acts, regulations in India. We also basically identify concerns. For example, if there are concerns with respect to standards, we also conduct webinars like this one and prepare case studies and other challenges about IPR in India. And then we have template agreements which are available on our website so that the European companies could use it as kind of a template for making collaborations. It is important for European SMEs to protect their inventions in India, and since this kind of service was not available, we opened up a service wherein we basically provide filing support to the European companies, especially the SMEs, to file in India. And this reduces the risk of infringing, because if you have locally filed in, it is much better to fight it out in case there is an infringement in a timely manner, rather than if there is some violation at the borders and customs. So you see, we basically provide prosecution support, risk, reduce IP risk and registration with the Indian companies. We also provide low-cost IP services, which are basically prior art, validity searches, prosecution support, identification for target entities for technology transfer. In addition, we prepare normally landscapes. The Indian database is not as comprehensive as other databases, for example, EPO, USPTO and others, but what best we can actually query out from the database, we try to prepare clean technology scenario in India and post it on our website along with our findings. It is also a good way of identifying who are the companies operating in India for matchmaking and technology transfer. We also do commercialization studies like patent commercialization. Many European companies have pool of patents which are lying unutilized just because either the standards in Europe have increased or those technologies have been taken over by better and newer technologies. But still those technologies could be easily adapted in India, and this is what we pitch to our we pitch in our technology commercialization space, that if you have these technologies which are lying unutilized, we can always use them and basically bring those technologies into India. We can customize, adopt these technologies, and once they are adopted or adapted, then we can basically seamlessly provide these technologies in India. We also provide due diligence studies where we provide due diligence reports, freedom to operate searches, wherein, for example, you introducing a new product into India and you want to know whether there are patents over which it is likely to overlap. Such studies are also provided. Note, these are comprehensive studies, and therefore these are at cost to cost basis, whatever cost we get from from our partners who would be conducting these searches, because if it has to be searched on an Indian database, we can do it for free, but in case it requires comprehensive research before a launch of a product, we get it done through our consultants. Coming to the main part of the presentation, these are the acts and regulations in India, and most of these acts have been recently amended in last decade to comply with the TRIPS agreement. So as you see, the Indian Patent Act 1970 was again amended by patent rules, and subsequently again amended in patent in 2005 to ensure that these rules and amendments comply with TRIPS agreement, to which the India was signatory. Likewise, in trademark, the trademark major act is the 1999 Act. However, it was again amended by Trademark Rules 2002 to comply with the TRIPS agreement. The Indian Copyright Act, as usual, is 1951, which is the base act for this, and the Design Act 2000 and Rules 2001 are the statutes here in the Design Act. The Geographical Indications of Goods, Registration and Protections Act 1999, another important landmark which came into force after India became a signatory, and likewise there was again an amendment to this act by Protection Act Rules 2002. As you see, all these rules have been enacted in summary to comply with TRIPS agreement, and therefore most of the rules or the acts are in compliance with the international obligation as per the trade-related intellectual property rights. This was a survey we did on the IPR front to identify what are the challenges available in the IPR space, especially with respect to what the companies have the perception and what are the specific challenges to SMEs. And here was the objectives of this one. It was to investigate and identify the IPR challenges and issues and address them in order to understand and facilitate implementation of IP rights between companies in the EU and India, provide practical information about IPR in case some of them are not informed. We would probably, the idea was to identify what information they require and put it in the portal, and then if there are any technology transfers, what are the main IPR issues which come into focus. And then the final objective, which we are now complying, and it is almost on the status of final implementation, is to build an online portal on Indian and European databases as to how this. We are happy to note that our findings were much in line with what is actually perceived, and I am going to basically discuss these findings in subsequent slides. So the findings were what happens when about IPR, what is the perception about IPR? It is 78% of the people said that yes, IPR is important in India, and while others did not feel that it is as important because either they were not using the IPR or IPR was not a focus in their product strategy, or the product lines were almost out of the patent space. So it was observed that big companies, especially the big European companies, pharmaceutical companies, exclusively use IPR. They protect their IPR and they are worried about it. And most of the small companies have these IPRs, but they are not making use of it to the fullest extent as possible. And this is because there is either insufficient knowledge of IPR in these small companies, or they are specifically catering to a very niche market where this is not as important. But one thing was common across, that everyone was worried about the IPR issue and they wanted to know more about it through some dissemination means. So to address these issues, we basically started capacity building programs, and now we regularly conduct IPR capacity building programs across India. The list is available on our website and you can have a look at it. The conclusions of this survey was that there is a lack of knowledge about Indian IPRs or Indian rules, regulations and statutes among European investors, especially the SMEs part, and they are also worried about what happens if there is an infringement and how do you redress that, where to approach, how to approach. So this was one of the major concerns out of this survey. The second one was there was insufficient case laws in specific to certain IP issues. For example, we recently had the issue where the Article 3D in the Indian Patent Act, which is to stop evergreening of patents, was validated by the Honorable Supreme Court of India. So these kind of rules are not explicitly available, but so they felt that if the case law is not there, how it is going to be addressed when it comes to court, so to the court, and they were a bit worried as to what would be the outcome of that specific kind of maybe of a specific case in IP. So this was another concern. There was also something with respect to design and drawings, where India is not a contracting party for the Hague Accord, and everyone felt that there is more requirement to disseminate information among European companies about the recent development of case laws in India. So the portal would be the best way of addressing such issues as to what is the recent and the most recent case laws, and what verdicts have come out of the courts, and how does it is going to help or it is not going to facilitate IPR development from the European perspective. To address these issues, EBTC has set up an IPR Helpdesk, which helps European companies for filing procedures which were normally perceived as cumbersome by SMEs. It also helps in guiding and helping European SMEs in protecting their IPR in India. So we address this concern by opening up an IPR Helpdesk, as I discussed in my previous slides. What the IPR Helpdesk is all about. To know more about it, please visit our website. IPR violations. In fact, the finding was that big and small companies are equally affected by IPR violations, and it takes extremely long time to address the violations, especially in Indian courts. In fact, one of the findings was that I think recently in August there was it was informed to the Parliament that almost 153,000 cases are pending for patent examination with the patent officers, and that's a huge number. And with these numbers, you can see how long it would take to actually grant a patent which is filed today. And with no patent term restoration, it is very difficult to protect the IPR for 20 years in India. So these were some of the concerns with respect to violations. They felt that there were not adequate data security laws, and whatever has to be addressed was through a contractual agreement which was weak when it comes to courts. So these were the conclusion of the studies. Now I will move further to the trends of IPR in India. I just wanted to say this was the methodology followed. We had a roundtable conference and a brainstorming session We publish the white paper and FAQs, which would be available on our website. And we are finally developing an online portal for providing advocate information about various issues in IPR, about the Act, about the aspects which needs to be considered, including a development of a game in future wherein you can play the game and learn more about IPR in India. So these are some of the innovative exercises we are taking it to ensure that there is a medium to basically disseminate information and build capacity on IPR in India, especially for European SMEs. To come up to the structure for my European friends is that the IP office basically falls under Ministry of Commerce in India, which is the Department of Industrial Promotion and Policy, same one which is basically drafting the manufacturing policy and also the innovation policy. Then there is an Office of Controller General of Patents, Design and Trademarks. The design wing of Indian Patent Office is basically located at Kolkata, so they look after the entire design issues. There are 4 patent offices which specifically cater to patents, so you can file patents as per your nearest regional office, which is basically located at all 4 directions, north, west, east, south. So likewise as depicted. And there are 5 offices for trademark registry. Apart from the 4, Ahmedabad is another one where you can do the trademark registry. Sorry. One office for geographical indication registry, which is located at Chennai. This office basically is for GI only, so it basically caters to geographical indications. And then finally, there is a National Institute of Intellectual Property and Management and the Patent Information System, which basically provides training, capacity building, and also about patent information services in India. The filing trends in India has been very encouraging. This is a trend which was published by the annual report 2010-11 of the Indian Patent Office, and the graphs have been derived from those data. As you can see that there's a continuous increase in filing. There's a small decrease in 2010 when the patent office was under modernization and digitalization, and there is no recessionary effect of filing in India, and large number of foreign filings are continuously being done into India, which is an encouraging trend from the perspective of IPR in India. Likewise, in trademark, as you can see, there is a continuous increase of filing in trademarks. Although it seems that there is a shortage of manpower for handling trademark cases, especially registrations and examinations. And another interesting fact was that somehow the trademark is more mature in India, and we had more oppositions to trademark in 2010 alone, which accounted to 8,251. Which is quite a large number, like in a developed structure of IPR regime in any of the developed countries. So it seems that the trademark is the mature part, and patents is on path of maturity. And likewise, GI, there was an increase in filing in 2008 and 9, and subsequently it may be so that there were not many geographical indicators to be filed in India, so it has started decreasing, but I understand that this trend would be interesting to note when we have more data about 2011, 12, and 12, 13. This is the comparative trend of granted IPR in India. As you can see that 2005, when the TRIPS agreement compliant things came into procedure, there was certainly a huge increase in filing, and subsequently it stabilized to a demand, and as you see that in 9 and 10 there was substantially less filing. I think the patent office examined less applications due to large resources being applied to digitalization as per the report, and subsequently it has again started increasing, and it would be interesting to know in future as to how these developments go further. An interesting aspect which comes out from the top R&D organization is that from the data it seems that the CSIR, which is always the highest filer in India for patents, is not always followed by the same set of 10s. So if you see a very mature economy, you will find that normally the first 10 filers would be changing positions and they would be same. But if you compare the report which was given in 2009 and 10 and 10 and 11, you will find that there is a drastic change of positions and new entrants have come in. For example, if you see in 2009 and 10, you will find that certain organizations which did not figured in the previous year were suddenly there. So this is an interesting thing. What are the reasons behind it? We have not been able to ascertain that. There was not much information, but it was good enough to note that new companies actually take positions and old move out, or they may have fallen below the first 10 mark. There are certain important challenges in India specific to Section D, which is of highest concern to European companies, especially after Novartis lost the case in the Honorable Supreme Court. The compulsory licensing issue in Bayer was not very encouraging and was a setback to European companies. In fact, all this seem to indicate that there is going to be more mature case laws in future, and it would basically determine the path as to how the IPR moves out in India and whether the regime would be soft or whether the regime would be strong or soft or weak. We cannot say as of now, but it will be important. It will be good to see how it moves on further. There is a lot of focus on innovation in the new IPR policy, but unfortunately the compulsory licensing issue is also there for clean tech sector, which is not very encouraging. It seems that the 3D section seems to favor the generic manufacturers, although it is evident that it is meant to stop evergreening of patents. So I think these are important facts which I need to bring to you, and it may be good to analyze them separately because what it actually appears in the picture may not actually be the case. So it depends from a strategy perspective of a company as to how they view the IPR scenario, what are their product lines, how these products are placed in India, if they are completely innovative. I think there is no reason that they are not be granted at patents. But on the pharmaceutical side, we would always say that be a little cautious when you enter India and do your due diligence, or probably contact our Helpdesk to get more insights about it. And there's another Section 8 of Indian Patent Act which is not very good for European companies, is about revoking a patent on non-filing of information. So if you see, I'm going to discuss it in detail. As you see, Section 3D states that the mere discovery of new form of known substance which does not result in enhancement of the known efficacy of that substance, or the mere discovery of any new property or any new use of a known substance, or of mere use of the known process, machine, apparatus, unless such known process results in new product or employs at least one of the new reactants, is not patentable. So it is a very broad and comprehensive way of representing things, but there are certain things which seems to be not in line as to what is efficiency, how it is going to be determined, what are the important elements, and how the patent office are going to do. But on the positive side, as I have depicted here, that it is not always the case wherein the applicant is able to show an increased efficacy, then the patent office is quite liberal in granting it. So it is not as dark as it looks. It is encouraging. If you are able to show the increase in efficacy, you are likely to get the patent. So likewise, as I told you that what is the mere new use of the known cannot be patented, how does the therapeutic efficiency be determined, validity of Article 3D under TRIPS and WTO, all these things are basically not very clear as to how they would be determined. But with the verdict of this Honorable Supreme Court, it seems that it is a little more clearer, and how you are going to use it in further case laws is likely to come up when more cases about these things come up. Moving to Section 8, okay. The Section 8 states that you need to basically file with the controller if you are pursuing an application in another country, or you are pursuing a substantially a kind what we call as patent family in another country. Now, there are issues as to what all you need to disclose. What does substantially same invention mean? Does it mean the entire patent family has to be disclosed? To what extent substantially same invention constitutes? So that is an important aspect that needs to be clear. What is the difference in information to be provided under Section 8.1, which I have shown above, and Section 8.2? Does detail regarding the process of application in a country outside India, including examination reports, prior arts and other things, needs to be filed completely, or what part, or you just need to report? So there are varying facts, and it seems that there are cases where everything was fine and the patent was revoked because it did not comply with Section 8, or there was insufficient information. Now, to what extent this compliance is and how the Section 8 has to be interpreted is difficult to ascertain, and therefore it poses another challenge when you are basically doing a national phase or a PCT filing, or you are basically having a voluminous translation of these documents in case you have filed it in another language. So this again poses another challenge for European companies. In fact, all is not that great. I have given you the flip side. Now there's a positive side. In fact, in one of the cases, the Supreme Court remarked that all hearings in intellectual property matters should proceed on day-to-day basis, and final judgment should be given normally between 4 months. And I think this is a very positive development from the highest court in the country, that IPR needs to be given more weight. It should not be that it is something which is going to cause economic loss for companies, and this has been noted specifically by the court, by this Honorable Supreme Court of India. And I hope that with this verdict and producing a case law would be quite interesting in future. In fact, most of the law firms now don't go for injunction. They want to settle the case as soon as possible by producing this case law in the court. So, which is quite encouraging. And in a drug patent linkage mechanism, the Delhi High Court observed that wherein they basically denied an injunction and put up a fine of 6.75 lakhs to act as a deterrent for further action, wherein basically patent linkages were shown. You can read all about these cases online. There's a lot of stuff available there, but I just wanted to highlight these cases as to how the case law is actually developing in India. There are many more cases which are not discussed here, not because they were not important, because of the lack of time. And I just wanted to show some positive and some effects where the case law, once it is developed, would probably shape up the IPR in India. And these are some of the nodal agencies in India wherein you may have more information, or you may connect with them for either getting, these are basically facilitation centers specifically for people who want to have more in view about what kind of research are there, how to get research to research collaboration on IPR and other stuff. So you can either go and visit them. These are the official patent facilitation centers in India. So with this, I think now it's almost 45 minutes. I have completed the presentation, and I hope that it was useful to you, and I hope that I would have been able to give you both the flip and the bright sides of the IPR, how the case law is developing in India and what it holds the future. So the IPR in India is not as weak as it seems to be. It is strong. There have been strong regulations. There are cases wherein these regulations have been validated by the courts in India, and I hope that the development of case laws would add further teeth to the IPR in India, and hopefully it will come out stronger and for protecting innovations in India. So thank you for your patient listening. I am free to take up questions. In case there are any, I will take them one by one till the time we have. Questions, please either text it to me or you can raise hands and ask the questions. The floor is open for the audience. I have two questions. I have two observations which are in form of questions. Mr. Gerard Wipsler says that he doesn't has any further questions. Anyone? The previous presentation was on commercialization of technologies, and in case you have questions regarding technology transfer and others, you are also most welcome to ask that about issues of IPR and technology transfers and other things. If you, there's a question about so there's a question by Rahul by Raj Gurtu. He says we are trying to find out joint ventures in biotech. Kindly advise us. Raj, please write to us in an email. I have my email address chopra@ebtc.com about the specific technology requirements, and I would be able to send you. You can have the email address on the slide, on the last slide, along with my headshot. Please send details to me and I will try to help you. So this is Ashish Bardwaj who said I have two questions. Is for patents or not? Another key question is accident is to go for patents or not? I think it makes sense to go for patents. There are no specific trade secret laws in India as such. And this is a kind of a lacuna, but there are discussions of introducing trade secret laws in India. But I would say that in case the technology is, there are two things when you go for a patent. One, Ashish, is that you basically need to ascertain whether the technology is rapidly changing in that area. If so, then patents are the best form to protect your inventions. If you could be a Coca-Cola, wherein you have a trade secret for almost 100 years and still want to preserve it, I think then trade secret is a better way of doing it. But as of now, in India, there are no trade secret laws. And if you want a collaboration on the trade secret, it is going to be difficult. It is, in fact, it is going to be very difficult. So, Ashish, I think, again, Ashish, I would say that when you are commercializing a technology in India, in fact, IPR protection is a major challenge when it comes to, and if you are not properly advised on it, you might lose it. For example, I can give you certain examples. The very first example is if if you become overexcited of your technology and someone offers that, okay, they are going to commercialize it in India and you will get huge profits out of it, and you disclose them without signing proper adequate legal documents, for example, confidentiality agreements or NDAs, you are likely to get into trouble. But if the technology is, you get into proper agreements, contractual agreements, specifically NDAs, confidentiality agreements, and you disclose the technology thereafter with proper validations, it is highly likely that you would be able to protect your inventions or technologies in India. Regarding techno entrepreneurship, I don't think techno entrepreneurship is a major issue, expect the fact that funding is again an issue. For example, we have a couple of requests from Europe about commercializing technologies in India, but these technologies are specifically for public utilization. Now, it is a huge challenge to identify how fundings could be provided to such technologies. Either it has to be government funded, or it has to be EU funded, or it has to be jointly funded, or there is a funding from international banks like ADB, World Bank. So these are the major challenge in the techno entrepreneurship is about funding. So if you have the funding, then it is not a big challenge. But specifically, IP related protection does have a challenge if you do not follow a right mechanism to protect it before disclosing the technologies. Raj, I am based in India. I am based in New Delhi. Okay, so if you write to me, it would be good to know where you are based, because I can locally introduce our office people there. For example, our biotech expert sits in Bangalore. So if you write an email to me, I will get her introduced to you over email. In case you are located in southern region, then she would be best able to help you out. Alternatively, if you are based in any northern region, then you can always directly connect with us. We will ensure that whatever is your requirement is met through. Okay, Raj, if you're based in Chennai, I think once you write an email, I will introduce you to our sector specialist in biotech. She's based out in Bangalore, and there you can always connect with her. She always have a lot of opportunities there. And we were recently into science and technology initiative between EU and India, and there were a lot more collaboration projects. Maybe some technology overlaps with you, and then you can basically get in touch with the European company and make a collaboration there. Yes, Ashish, you can always say that data availability is a challenge. For example, if you go to the database of Indian Patent Office and you search for clean tech, you will not find all the technologies. There are many more who have been filed, granted, and available. So, in fact, the European Patent Office is working closely with the Indian Patent Office to do digitalization of patent information system, but till now it has not been done. The patent information system is a key deterrent, because if you do not have the right information, you cannot conduct a freedom to operate search for your technology bringing into India. It may so happen that you miss a patent and later on you get into infringement challenge. So this is really a challenge, as I can see. In fact, we also feel that way sometimes. So I agree with you that data availability on the patent aspects is a challenge. Okay, Ashish? I think data aspects, we work very closely with the European Patent Office, and they are doing a lot of workshops, and I think I'll have more information when the Director on Patent Information System, who was earlier here in August, again visits us about the developments. But definitely there is something is going on. I do not have the details to discuss it right now. Yes, that's true. The EPO is actually working to get an entire thing done, but I am not sure to what level they have been succeeded, because it is not a challenge. It is a challenge within, I think, the company who was digitalizing the patent information system in India itself does not find adequate reports. In fact, if you want specific information that is as costly as a Delphian account, okay, a TI, which is a TI account somewhere around $2,000 per year. Okay, what they do is they collect the patent information from the patent office. They buy it, whatever they do, I do not know. They were in touch with me a while ago. What they do is that they completely buy this data, prune this, sanitize the data, and then present it. So it's a long, tedious process, and therefore they charge very high amount of money for those databases. If you want, I can probably be able to introduce you to them in case there is specific requirement, but each search costs more. And again, as I tell you this, that data is also not very authentic, because I gave them something to work on, and it seems that the results were not as good as I would have expected to be. Therefore, definitely there is something missing there also. But that seems to be the best answer available as of now. These are commercial companies who basically buy databases, take papers, digitalize them, correct them. For example, like they tell us, in many cases the abstract does not correlate with the title. So all these aspects they take care of. But again, the limitation of the database is to the extent of what they have access to. See, there are not specifically, Ashish, we do not provide valuation tools, but yes, if standbys, I'm not sure, you're from Planck Institute, if I'm correct, Max Planck. If you want to work exclusively on such kind of projects, you can write an email to me, and we can identify opportunities, because we are also looking as to how technologies, good IP analysis can be done on the valuation part. Because again, if you see, valuation is something which is more difficult to comprehend in terms of patents. So if you write about this to me, we can see what you are working on. I have an extensive experience working on valuation models, doing mergers and acquisitions in US, and doing the entire 360 degrees of patent valuation, but it takes huge amount of time. But we can certainly work out something, or we can basically collaborate on that front to find out. So I think we would probably finish this discussion if there is no more questions. Anyone can again just a reminder before I say thank you to all. Please feel free to email me on any aspect if you want to collaborate, if you want to become EBTC's partner in doing some joint projects. EBTC is not EBTC is only in India, Rahul. EBTC is basically European Business and Technology Center. In Southeast Asia, the European Union runs different projects. For example, in China, it is the SME China. In Bangkok, it is, in Thailand, it is another separate project. So we do not cater to entire Southeast Asia. We are only present in India. So any Indian collaboration or any joint projects on IPR, if you are specifically interested, do write to us, and we will basically try to address those things or work out a solution, or at least if not, we can mutually see if something important for general public would be published with a finding or a research in that domain. If everyone is fine, then I would take leave of you. Thank you very much for listening to me, and have a wonderful evening here in India and a wonderful afternoon in Europe. Thank you.